Hello everyone. Today we are going to discuss about human rights. We'll see. Objectives. The students is able to explain what is human rights, narrate the different aspect of fundamental rights, enlist the types of rights. We'll see one by one. Introduction. The fundamental rights in India, enshrined in Part 3 of the Constitution of India, guarantee civil liberties such that all Indians can lead their lives in peace and harmony as citizens of India. These rights are known as fundamental as they are the most essential for all-round development. Example, material, intellectual, moral, and spiritual, and protected by fundamental law of the land, that is constitutions. The rights provided by constitution, the fundamental rights have been damaged, the parliament they can take strict action according to article 33. These include individual rights common to most liberal democracies such as equality before law, freedom of speech and expression, freedom of association and peaceful assembly, freedom to practice religion, and the right to constitutional remedies for the protection of civil rights by means of writs such as habeas corpus. Violation of these rights result in punishment as prescribed in the Indian Penal Code, subject to discretion of the judiciary. The fundamental rights are defined as basic human freedom, where every Indian citizen has the right to enjoy for a proper and harmonious development of personality and life. These rights apply universally to all citizens of India, irrespective of their race, place of birth, religion, caste, or gender. They are enforceable by the courts subject to certain restrictions. We'll see what is human rights. Human rights are rights inherent to all human beings regardless of race, sex, nationality, ethnicity, language, religion, or any other status. Human rights include the right to life and liberty, freedom from slavery and torture, freedom of opinion and expression, the right to work and education, and many more. We'll see what is fundamental rights. Here the first one is right to equality, that shows article 14 to 18, and right to freedom, article 19 to 22, right against exploitations, article 23 to 24, right to freedom of religion, article 25 to 28, cultural and educational rights, article 29 to 30, right to constitutional remedies, article 32. The first one is right to equality. That is article 14 to 18. The right to equality provides for the equal treatment of everyone before the law, prevents discrimination on various grounds, treats everybody as equals in the matter of public employment, and abolishes untouchability and titles. Then we are moving on to right to freedom, that articles 19 to 22. Right to freedom deals with the basic and the most vital rights of the Indian citizen. Article 19 to 22 of the Indian Constitution provides the right to freedom that aims to protect the fundamental freedoms of the Indian citizens like freedom of personal life, freedom of speech and expression, freedom to live dignified life, freedom to form association, and a lot more. This is what right to freedom. The next one is right against exploitations. Right against exploitation enshrined in Article 23 and 24 of the Indian Constitution guarantees human dignity and protect people from any such exploitation, thus upholding the principles of human dignity and liberty upon which the Indian Constitution is based. Prohibition of traffic in human beings and forced labor. Clause 1 of Article 23 prohibits the trafficking of human beings, beggary, and similar form of forced labor. It also states that any contravention of this provision is punishable by the law. It explicitly prohibits human trafficking. This refers to the sale and purchase of human beings mostly for the purpose of sexual slavery, forced prostitution, or forced labor. Even though we have rights against exploitation, it is still happening in India, but most of them are not aware about the rights which they have. Again, under the rights against exploitation, beggar. This is one of the most common thing happening. The beggar, this is a form of forced labor which refers to forcing a person to work for no remuneration. Other forms of forced labor, this includes the other forms of forced labor in which the person works for a wage less than the minimum wage. Even what they are eligible, that money they won't get, but they'll work less money but they'll do more job. This includes bonded labor, wherein a person is forced to work to pay off his debt for inadequate remuneration; prison labor, wherein prisoners sentenced for rigorous imprisonment are forced to work without even minimum remuneration. Sometimes the people even without payment also they will work, and sometimes they'll with less money they'll work. These things has should not be happen under the rights against exploitation. Next one is a right to freedom of religion. Yeah, of course, everybody has right to select their religion. This is what telling under this article 25 to 28. Article of 25th of the Constitution guarantees freedom of religion to all persons in India. It provides that all persons in India, subject to public order, morality, health, and other provisions, are equally entitled to freedom of conscience and have the right to freely profess, practice, and propagate religion. It further provides that this article shall not affect any existing law and shall not prevent the state from making any law relating to regulation or restriction of any economic, financial, political, or any secular activity associated with the religious practice. And again, right to freedom of religion, providing social welfare and reform, opening of Hindu religious institution of public character for all the classes and section of the Hindus. The Supreme Court in Tilkayat Shri Govindalalji Maharaj V state of Rajasthan held that the test to determine the questions in deciding what is an integral part of the religion is whether it is regarded as integral by the community following that religion or not. Cultural and educational rights. It is article under 2930. Fundamental rights guarantee basic rights to the citizens of India. There are six fundamental rights enshrined in the Constitution of India, and articles 29 and 30 deals with the cultural and educational rights of Indian citizens. These fundamental rights intend to preserve the culture of minority groups in India. Indian society is a composed, heterogeneous one, and its diversity is one of its strengths. The Constitution guarantees these rights to minorities so that the diversity of this country is preserved and provides avenues for all groups, including marginalized ones, to protect, preserve, and propagate their cultures. Article 29, protection of interests of minorities, and this article is intended to protect the interests of minority groups. Article 29 again, this provides any section of the citizens residing in India having a distinct culture, language, or script the right to conserve these cultures, language, and script. And then the state shall not deny admission into educational institution maintained by it or those that receives aid from it to any person based only on race, religion, caste, language, or any of them. So any case they should not be denied any service, they can get it from government. Cultural and educational rights. Article 30, right of minorities to establish and administer educational institutions. This right is given to minorities to form and govern their own educational institutions. Article 30 is also called the Charter of Educational Rights. Article 30 again, all religious and linguistic minorities have the right to establish and administer educational institution of their choice. And the state shall not, when granting aid to educational institution, discriminate against any educational institution on the ground that it is under the management of minority, whether based on religion or language. A right to constitutional remedies. the ground that it is under the management of minority, whether based on religion or language. And under this right to constitutional remedies, we have a writ. What is the writ? Writs are written orders issued by the Supreme Court of India to provide constitutional remedies to protect the fundamental rights of citizens from a violation. We can see some facts about rights in India. Article 32 also empowers Parliament to authorize any other court to issue these writs. Before 1950, only the High Courts of Calcutta, Bombay, and Madras had the power to issue the writs. Article 226 empowers all the High Courts of India to issue the writs. Writs of India are borrowed from English law, where they are known as prerogative writs. What is a writ petition? Writ petition is essentially a court petition for extraordinary review, asking a court to intervene in lower court's decisions. Under the Indian legal system, jurisdiction to issue prerogative writs is given to the Supreme Court and the High Courts of Judiciary of all Indian states. Part of the law relating to writs are outlined in the constitutions of India. We see types of writs. The Constitution empowers the Supreme Court and High Courts to issue orders or writs. The types of writs are habeas corpus and certiorari, and two more writs are also available. First, we will see about the habeas corpus. Habeas corpus is a writ that is enforced to protect the fundamental rights to liberty of an individual against unlawful detentions. This writ commands a public official to deliver a detained person in front of the court and provide valid reason for the detention. However, this writ cannot be issued in case the proceeding is for contempt of legislation or a court. And certiorari writ, this writ is issued to a lower court directing that the transfer of a case for review, usually to overrule the judgment of the lower court. The Supreme Court issues the writ of certiorari in case the decision passed by the lower court is challenged by the party. It is issued in case the higher court finds it a matter of over jurisdiction or lack of jurisdictions. And it is one of the mechanisms by which the fundamental rights of the citizens are upheld. Then we'll see the prohibitions. Prohibition is a writ issued by higher court to a lower court to enforce inactivity in the jurisdictions. It happens only in case the higher court is of the discretion that the case falls outside the jurisdiction of the lower court. A writ of prohibition can only be issued against judicial and quasi-judicial authorities. Mandamus. The writ of mandamus is issued to a subordinate court, an officer of the government, or a corporation or the other institution commanding the performance of certain acts or duties. Unlike the habeas corpus, mandamus cannot be issued against a private individual. The writ of mandamus can be used to order the completion of a task, or in the other cases, it may require an activity to be ceased. And next one is quo warranto. Quo warranto is issued against a person who claims or usurps a public office. Through this writ, the court inquires by what authority the person support his or her claim. Through this writ, the court inquires into the legality of a claim of a person to a public office. This writ prevents the illegal assumption of a public office by an individual. Now we came to the end, that is conclusion. Human rights are standards that recognize and protect the dignity of all human beings. Human rights govern how individual human beings live in society with each other, as well as the relationship with the state and the obligation that the state have towards them. Teaching the basic principle of non-discrimination of the fundamental rights and freedoms shows that every human being has his rights and freedom. Reference: I have taken this content from www.humanrights. Thank you for watching my video. Thank you once again all.